Welcome to Cutler Legal Basic Law. Today we're going to talk about answering interrogatories. What is an interrogatory? An interrogatory is a question, written question to your opponent or to you in which you're to provide a written answer or your opponent provides a written answer. So today we're going to focus on the answers, not the interrogatories or preparing the interrogatories themselves, but answering them. First thing is, can you refuse the answer? No. You absolutely must answer the interrogatories. If you don't answer the interrogatories, the other side can bring you in front of the court, seek sanctions for not answering, including either the dismissal of your claim or if you're defendant, the dismissal of your answer, leading to entry of judgment against you. Very dangerous place to be. But what you can do is you can refuse to answer specific interrogatories. It's your answer. In other words, you answer the set. So there's 20 interrogatories asked of you. Of those 20, 5 are objectionable. Then you can refuse to answer them if you have a valid objection. That is a legally valid objection. It's not that I don't like the question or they've got the information themselves, they can go get it. They have it themselves in their own records or they can get it themselves. That's not a valid objection. A valid objection is, let's say, communications with counsel, something your attorney told you, then you don't have to disclose it. Or your spouse told you, you don't have to disclose it. Or your preacher told you, you don't have to disclose it. Or honestly, you may not understand what the interrogatory is. They're very hard to draft, and if you don't understand what it is, you may say, I don't understand what it's asking, and maybe you give your own spin as to what it's asking and answer what you understand it to be. Best place, look at the rules of evidence to see if it's in violation of any of the rules of evidence and any of these privileges, or if it's wholly irrelevant. Let's say you're being sued for breach of contract in the purchase of a car, and there are interrogatories asking about your child's daycare. Has nothing to do with your damages or your car. Then you could object, say it's irrelevant, not likely to lead to relevant information. This is intended simply to harass and embarrass me and cause me grief. That would be a valid objection to the interrogatories. Are your responses important? Extremely important, because they bind you. And what you answer as interrogatories can be used throughout the whole litigation. It can be used at summary judgment, and it can be used at trial. You could be asked questions on the stand, and if you change your testimony for what you stated in your interrogatories, your interrogatory responses can be used to impeach you. Remember, when you answer the interrogatories, you're signing them under oath, the same oath that you're taking in court. So if you're in front of the jury and you're asked a question and you answer the question differently than your interrogatories, the other side could bring forth the interrogatories and say, well, we asked you the same question, and in the interrogatories, under oath, you said this, the same oath you said you took today in front of this jury. A very embarrassing situation. So be very careful in answering the interrogatories. Also, leaving out information can be hurtful to you. The other side, at a later point, you go, well, we asked you to give all the instances surrounding the breach of contract, and you only gave us 3. Now you've given us an additional 5. You never disclosed those. You can go to the court and ask the court to exclude those additional 5 reasons, or say that those 5 reasons never existed because you never disclosed them before and you're just making them up now. Even though you knew them and you're perhaps not being careful in your answering and you should have included them but you weren't thinking, slow down, answer them thoroughly. It's one of those tricky places that can come back and bite you later on in the case. How do I draft responses? Like all pleadings, you start with the pleading head, name of the court, case number of the parties, responses to interrogatories, and the interrogatories are numbered 1, 2, 3, 4, and your answers follow that. Usually you restate the interrogatory, and then you say your answer. And you first start off with if you have any objections. You could assert objections, say, oh, I object, it's overbroad, it's harassing, but despite that, I'll still answer it. So you preserve your objection, and you answer. Or you could just object and not answer, or not object and answer the interrogatory. And at the end, you have to sign it saying, sign under pains and penalty of perjury, that these are true and correct statements. And then, of course, infamous proof of service at the end, in which you say you served it on all the parties to the action. So after you answer the interrogatories, you have to serve your responses on every party. So if there are multiple parties, and one party served you the interrogatories, everybody gets a copy of your answers, and everyone can use those responses in any fashion they deem appropriate and permissible under the law. There are time limits. Normally, you have 45 days to answer interrogatories. The other side is often willing to grant you additional time because they're difficult to answer and they expect the same courtesy back. But if a party has to go to court to get you to answer, the court can order that you have to answer the interrogatories without any objections. So if you had objections or wanted to make objections and you don't answer, the court can take away your right to object and force you to answer. And that may be a difficult situation to be in. Court could also grant financial sanctions against you for not answering, the cost of bringing the motion, or in some states, if the party follows certain steps, they can get your case dismissed for failure to answer. And that, of course, is the worst situation. Either your case dismissed, or if you're the defendant, your defense is dismissed. If you provide incomplete answers, and the other side can call you up and say, hey, your answers are incomplete. You should have given us more information on this, or this interrogatory asked for this or asked for that. Work with them. More often than not, it's best to go back and say, okay, I may disagree with you, but I'll go and I'll supplement it. I'll flush it out some more. Because if he goes to court or she goes to court and says that you provided incomplete answers, then and you've taken a very hard line, the court may hold that against you. But if you try to cooperate and supplement, the court might look sympathetically upon you, saying, look, you try to do the right thing, and the other side is being unreasonable. And again, in front of the court, it's always about who's reasonable. That's what the judges tend to look most favorably upon, is the party that's most reasonable. At a later date, may you revise your interrogatories? Absolutely. You can provide what are called supplemental responses. Things happen. You get additional information. Things come out in depositions. You see additional documents. You learn something from some other source. You can go back and supplement. In some courts, you're required to go back and supplement if you get new information to bring them current. If you change your interrogatories substantially, then that's problematic. You can do it, but the other side may comment on it at trial if it works for them to show that your story is changing. You used to say the light was green, now you say the light was yellow, and you've changed your story. So you just want to be a little careful about what you do when you do the supplements. As with the original interrogatories, make sure your supplemental interrogatories are signed under pains and penalty of perjury. Do not delay in supplementing interrogatories. If you find new facts or additional facts, do it right away, because you can supplement many, many times with new facts. You don't ever want to be in the position of being accused of unreasonably delaying in supplementing your interrogatories. Like document requests and depositions, interrogatories are very powerful discovery tools, and in responding to them, be very careful. Thank you.